Well, good morning, everybody, and welcome to the Landmark Chambers webinar, Judicial Review and the Courts Bill. We're delighted to see so many people joining us this morning. We hope that you'll find the presentations and discussion to be useful and informative. My name is David QC. I'll chair the session today. I'm joined by my colleagues Richard Drabble QC and David Elvin QC, who I'll formally introduce in a moment. But to begin with, just a few housekeeping points. Your microphone should be automatically muted, so you won't need to adjust the settings. We very much welcome questions throughout the session. Please submit them via text in the Q&A section, which you should be able to find at the top or the bottom of your screen, depending on how you're accessing the session. We will endeavour to answer as many questions as we can at the end of the presentations. This webinar is going to be recorded. You'll receive a link to the webinar at the end. And if your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. So let's begin. This is a session with three speakers. I'm going to say a few words about the background to the Judicial Review and Courts Bill. I'm then going to hand over to my colleague David Elvin, who's going to look at new clause 1, the provisions with respect to quashing orders. And then he'll in turn hand over to Richard Drabble QC, who's going to look at the reversal of CART, presumptions and statutory interpretation. David and Richard need little introduction. They're both hugely distinguished public lawyers and have extensive practices in the High Court, the Court of Appeal and the Supreme Court. In fact, I think other than James Eadie, Richard Drabble has appeared more times in the Supreme Court than anyone else. They both have considerable expertise in this area, and that expertise was recognised by the Bar Council, which engaged both of them to assist in its response to the government's proposals. And therefore, both David and Richard have been involved in the process of engagement leading up to this bill, right from the start. I'm going to start by talking about the background, because the background is that this is has taken quite a long time, and it has quite a political background. The first thing to say is it's been a very long and windy road to get to where we are at the moment. And in some ways, it's difficult to understand where the government has ended up without understanding something of the background. But in my view, there are three essential drivers behind the government's desire to reform judicial review law. It must be said that within government, indeed all governments, judicial review is fantastically unpopular. Government ministers don't like the idea that the exercise of their powers are going to be constrained by the courts. And when I was in government, I saw the extent to which government departments, particularly the Home Office, became vexed and angry and frustrated about what they would see as interferences by the judges getting in the way of the government getting on with its business. Now, obviously, I have no internal knowledge of the present government and the present structures, but I think it's a pretty fair bet to say that the opposition, entrenched opposition and irritation from government ministers towards the judges interfering on behalf of whoever is affected by government decisions is probably considerably more vociferous than it was under the previous government. There are, though, three sort of different strands coming together. The first is the Judicial Power Project, which I'm going to say a little about in a moment. Then there's the effect of the two Miller decisions. And then there's the internal reaction of a series of government ministers, particularly the character on the slide, who needs no introduction at all, but of course has now left government, and that may, and his departure from government may indeed have something to do with the present relatively modest proposals set out in the bill. Firstly, the Judicial Power Project. The Judicial Power Project is integral to the way the government sees judicial review. It's a project, it's called a project, but actually it's part of Policy Exchange, which is a broadly right-wing think tank, which is funded by people who are unidentified, but essentially those who have the money are able to fund think tank projects in order to advance their own interests and perspectives. And for a background to that, I've referenced Democracy for Sale, which is an interesting and very well-researched book by Peter Geohagen, and he gives a detailed and fascinating account to show how money can essentially buy influence through the use of think tanks. But the Judicial Power Project predates the various cases of Miller. It's led by Professor Richard Eakins of Oxford and Professor Graham Gee of Sheffield. And each of these professors essentially advance a thesis of judicial overreach, suggesting in their view, and it's a view, that the judges have engaged in undue interference in government decision-making. So it's essentially a small a judicial interference model for how law and politics should interact. And the aim of the project is to, quote, understand and correct the undue rise in judicial power. That makes the assumption there has been an undue rise, and that in itself is enormously controversial. So what does this mean in practice? The messages being given out by the Judicial Power Project through Policy Exchange is that the central idea is the decisions of Parliament ought not to be called into question by the courts, and the executive ought to be free from undue judicial interference, which fails to respect political judgment and discretion, which is effectively saying that review of the government should be done by Parliament, review of the executive by Parliament, and not by the courts. And there's a couple of other quotations there where they were particularly vexed by decisions of the courts, seeing as they interfering, as they would say, with the actions of the executive. We then move the stage of having set the Judicial Power Project up. The next big marker was the first Miller case, which was about whether or not, in order to reform the way out, or in order to create the way out of the European Union, to create Brexit, there had to be a primary act of Parliament, effectively to repeal the 1972 Act. And the decision was there should be an act of Parliament, and the response was extraordinary, typified by the Mail headline, which was very famous, the enemies of the people, as if the judges were interfering with the people rather than simply providing that the people's agenda should be carried forward in a lawful way. That reaction was even more intense against the judges using judicial review powers when the second Miller case about the prorogation of Parliament, where the Supreme Court decided unanimously that the powers exercised by the Prime Minister were essentially exercised improperly. And it's interesting to see the responses from people at senior levels in government. Kwasi Kwarteng said, many people are saying the judges are biased. Dominic Raab, now the Foreign Secretary, referred to an unholy alliance of die-hard Remain campaigners, a fund manager, and an unelected judiciary to thwart the wishes of the British people. And Chris Grayling spoke of judicial review as a promotional tool for left-wing campaigners and spoke of legislating to restrict its use. And that led to the 2019 Conservative Manifesto, which proposed to set up a Constitution, Democracy and Rights Commission to look at the relationship between government, parliament and the courts. Now that's not actually happened, but it formed the background to the present reforms of judicial review. What then happened was the government set up the Independent Review of Administrative Law under Lord Fawkes, who previously served as a Conservative minister. And the substance of that review was in paragraph 4 of the terms of reference, which I set out on the slide, but in summary asked the question, was it too easy to bring JR proceedings? Were they too much of a burden on government? Was the duty of candour justified? The members of IRL were interesting in that there were only two public lawyers, Cecilia Cahoon and Vikram Sakdeva, QC, who at that point was chair, I think he's still chair, of the Administrative Law Bar Association. IRL then put out a call for evidence, a policy paper which essentially invited responses from a range of people, but predominantly public bodies, against an agenda of restricting judicial review. It also published a discussion paper of, I think I can call it, doubtful historical legal accuracy, but was clearly inspired by Judicial Power Project, referring to judicial overreach. But as many commentators explained, a series of assumptions in the paper were somewhat inconsistent with decisions of the judges going back 30, 40, 50, even 100 years. There were a large number of responses to IRL, many of whom were not published and have been refused to be published by the government. But many of the responses were obviously published by the organisation that was responding. So ALBA produced a very impressive response. The Bar Council produced an impressive response, and all those are published. What happened then was that IRL produced its report in March this year. And essentially, the report did not support anything like the radical action on judicial review, which had been trailed as part of the setting up of the IRL project. In fact, in many ways, it must have been an enormous disappointment to the government, because what IRL recommended was reform of cart appeals, and Richard will talk about cart appeals. Nobody knows more about cart appeals than Richard Drabble, because he was in the original cart case, and a measure of flexibility on quashing orders, which, if looked at, and David Elvin will talk about this in detail, is not necessarily going to assist government bodies. It may well also assist claimants in different occasions. So the IRL report was, in a sense, a disappointment, because it didn't give the government the intellectual underpinning to pursue a reform programme in the way that it anticipated. What then happened was really quite extraordinary. The government then published a further consultation document, essentially picking up on a large number of issues that were raised in responses to to IRL, but not accepted by IRL itself, and essentially asked the question whether the Parliament should legislate further than IRL had recommended. That in turn produced a substantial response. I've given a few examples on the slide. A substantial response from those who had an interest, including the Bar Council, Richard and David were both involved. But we could see within that document, again, the influence of a Judicial Power Project, because Professor Eakins' views were reported as supporting some of the recommendations, which in turn had not been accepted by IRL after their proper analysis. So one can see that the government was getting, perhaps if I can put it, irritated that it set up the commission to come out with a response and hadn't got the response it wanted. And so that consultation then resulted essentially in the Judicial Review and Courts bills, which, as far as one can see, has not carried forward the more extensive recommendations or issues raised in the consultation, and has gone back to the limited reviews of administrative law recommended by IRL. So clause 1 is all about quashing orders, and clause 2 is about the removal of cart appeals. There may well be further reform of judicial review procedure, because the consultation paper talked about other changes which have to be brought in by the Civil Procedure Rules Committee, and those changes haven't yet happened. So, for example, IRL talked about the provision for a reply being an important document in JR, and the government is pressing for an extended period to file detailed grounds. What will come for that, we don't know. That's a matter of the Civil Procedure Rules Committee. So it's a somewhat peculiar history, which started with a degree of antagonism from government ministers towards the courts, has gone through a process, gone through a second process, and ended up with something which, on its face, and David and Richard can talk about this more, appears to be far more modest than the politicians were hoping, by way of essentially clipping the wings of the judges. The extent to which their wings have been clipped or not it is a matter to be looked at by my colleagues, and I'm now delighted to hand over to David Elvin to talk about the new provisions with respect to quashing orders. David, over to you.
Thank you, David. Good morning. As you'll see, the government on the website, which I've given you the reference in a couple of pages' time, it sets out the various documents relating to the proposed reforms. And there are a couple of fact sheets, including a judicial review fact sheet. And I've set out at the last two slides, just for ease of reference, there are two examples of the operation of the new powers in relation to quashing orders, which the fact sheet gives. However, the fact sheet does begin by repeating the mantra, which I've quoted here, which really is a throwback to the consultation response, which David has mentioned and which we're all familiar with. And it does appear to be slightly a case of the emperor's new clothes, because so far as clause 1 is concerned, clause 1 is effectively a reflection of the relatively modest suggestions made by IRL. So it's an attempt, I think, by government just to say, oh, well, we're still doing what we said we were going to do, when the reality is that it's, as David has mentioned, it's a far cry from what was proposed. And this is the key provision, clause 1, so far as quashing orders are concerned, a new section 29A to go into the Senior Courts Act, which, as you'll see from subsection 1 and 2, quashing orders can be suspended or postponed, and the retrospective effect of quashing can be removed or limited, and as subsection 2 provides, that may be subject to conditions. So the court may craft by express power the terms of the quashing order in those respects, even assuming that they didn't have power to do that in the first place, which was always open to question. Note in passing, and I'll come to this in a moment, under subsection 5, there's a provision made for something which did cause a great deal of heat and light at the time of the consultation paper, which is the issue of nullity and the effect of anisminic. And what the court, what is now proposed in the bill is not the creation of what might be called the law of unintended consequences by abolishing the principles of nullity altogether, or to limit them in some unexplained way. It simply says, as Folks recommended, that if the court is to have these powers to suspend or postpone, etc., then the fact that the decision might have been categorized as a nullity does not prevent the court exercising these powers. And it's to be noted, and as I say, I'll come back to this in a moment, that that only kicks in when subsections 3 or 4 are triggered, which is where the court upholds the impugned act in the limited way allowed by subsection 1A or 1B. And it raises an interesting question as to whether nullity can still be taken into account before you get there. I'll come to that in a moment. There is section 29A8 sets out mandatory considerations when the court is deciding whether to exercise a power in subsection 1. They are not exclusive, but they are mandatory to consider them, and they contain considerations which you would expect a court to have regard to in any event. I'll come back to the details in a moment. And subsection 9, a limited presumption is created that the court should make provision and apply subsection 1 if a subsection 1A or B order would, as a matter of substance, offer adequate redress in relation to the relevant defect. And if that is the case, the court must exercise the powers unless it sees good reason not to do so. And in doing so, subsection 10 provides that the court should take into account in particular subsection 8E, which is any action proposed to be taken or already taken or undertaking given. So that the government clearly has in mind matters such as promises by the relevant government department to legislate to amend the regulations if it's a regulation issue, or to take some other action. And there are powers, as you've seen in passing, to limit retrospective effect or to vary the dates to allow the orders to be varied. There are then consequential amendments, and the provisions are to come into force only in respect of proceedings which have been commenced on or after the coming into force of those provisions. I've given you, as I promised, 2 web references which will allow you to see the various matters, including the fact sheets and the consultation papers. So, as I've said, a far less radical change to the law. Indeed, it is effectively a slight enlargement, or an express enlargement at least, beyond any argument to the contrary, that the court has got wider powers in deciding whether or not to quash, not merely the discretion not to quash, but postponement, suspension, imposition of conditions, etc. It's difficult to see this as being targeted at anything other largely than government regulations and government policy. And indeed, if you read the original consultation draft, and indeed the explanatory notes that go with the bill, clearly the government has in mind its ability to change regulations and to repair defects, rather than have the problems created by a retrospective quashing order. The limited presumption, as I've already mentioned, and the important aspect of all of this is it leaves it to the court to make decisions, even in the case of the presumption. For example, in particular, in the case of the presumption, does the use of a section 29A1 order provide adequate redress, whatever that means? And even if it does the court have good reasons for not exercising the power? So those critical questions are not taken away from the court. There's no suggestion, as was in the consultation paper, that the court would have to exercise the postponement or suspension powers unless there were exceptional circumstances, which was the Ministry of Justice's original take on this, but leaves it very much in the hands of the court. So it is creating effectively further tools by express powers that the court can operate in circumstances where it considers it appropriate, applying, of course, the relevant legal tests in 29A9. And on the nullity question first, in the Ahmed case, which was debated in IRL, the Supreme Court had declined to suspend an order, not on the basis that it didn't have power to do so, but because it would obfuscate the effect of a void act. IRL treated it pragmatically and dismissed some of the academic comments and referred to the fact that the common law's adherence to the metaphysics of nullity never been more than half-hearted, and indeed all of those of us who practice know that it doesn't play a major role in judicial review. It just remains an issue which will arise from time to time. So rather than create potentially unintended consequences, the bill now follows IRL, having been warned by many of the law of unintended consequences, and simply makes provision that where and to the extent that the impugned act is upheld by virtue of subsection 3 or 4, it is to be treated as if its validity and force were and always had been unimpaired by the relevant defect. So it's intended to facilitate that, but it does raise questions. Before the court reaches the point of exercising the subsection 3 or 4 powers, it does remain a question as to whether the court can take it into account, either in terms of adequacy, or because it's got to look at the nature and consequences of the defect, or whether it looks at it in terms of good reasons. The modification of the effect of nullity is a very limited one, and it remains to be seen whether, in fact, the courts use this as a basis for excluding nullity altogether. That seems unlikely, even when the powers are in play, but in fact may remain relevant, particularly if you're looking at the consequences of the act and its impact on persons or groups of persons and its forward effect. And you'll see in the explanatory notes, the explanation is not particularly enlightening. It's a statement of the obvious, perhaps, and the fact sheet is silent on the issue. So turning to the exercise of the power, as I've said, it's fairly wide-ranging in terms of the ability of the court to modify the quashing order, both in terms of limiting its effect, suspending its effect, or postponing its effect. And the limited presumption, as I've already said, is subject to the question of whether there is adequate redress and whether, if so, there is good reason. And the court must look at what is being offered in terms of the party responsible for the decision. So the government department, I suppose, can come forward and say, we give the court an undertaking to lay new regulations before Parliament, amending the provisions and removing the relevant defect. Or we propose that the court's order is postponed for a period to allow further steps to be taken. But as I say, that leaves critical questions to the court. And an example of the issues that might arise arose in Lord Nicholls' judgment in Re Spectrum Plus. Well, not just Lord Nicholls, Lord Hope as well. That was dealing with prospective overruling, but that deals with a similar issue to prospective quashing. And he sets out in the paragraphs I've noted the difficulties with prospective remedies, that although the ability to grant a prospective only remedy wasn't incompatible with the function of the courts, but they may not be suitable, for example, because it may cause unfairness, leaving the victims of an unlawful act without a remedy, or a discrimination, potentially unlawfully or unfairly discriminating between those who were affected by the provision before the quashing order and those who can take the benefit of a prospective order. And this may provide some indications as to whether the courts will be too enthusiastic about applying these powers. And the non-exhaustive but mandatory factors set out in subsection 8 give the court a very full series of powers to consider all issues of fairness, unfairness, arbitrariness, discrimination, and any other relevant issues in order to consider whether the remedy is an appropriate one, invoking, in other words, subsection 1. And they include not only nature and circumstances of the defect, and hence my comments earlier on nullity, detriment to good administration, which is clearly of vital interest to the government, that wishes not to have to unwind immediately or unwind at all the previous effects of a defective regulation or potential policy requirement. The interests or expectations of those who would benefit from quashing. And of course, one must bear in mind that those seeking quashing order may be merely representing a particular interest, which many are awaiting on the outcome in order to see what view the court takes as to the challenged act. Others may have relied on the impugned act. For example, developers relying on a grant of planning permission, or a policy which has benefit, or regulations which have benefited some but not others. So far as appears to the court to be relevant, any action taken or proposed to be taken or undertaken. That's the subsection 8E point, which I've already mentioned. And any other matter the court considers to be relevant. So, as I said, the factors are not exclusive, and the court has a wide-ranging discretion to consider, as it does in any event with regard to quashing orders, the circumstances and implications of making the order. And coming back to subsection E, as I've already mentioned, this gives government, and clearly they're interested in this because the consultation paper refers to it, as do the explanatory notes. One asks questions with a defective regulation, for example, will it be sufficient if the claimant is provided with redress even if others are not? For example, the payment of compensation as a condition for not quashing. The difficulty with that is that the extent of the unlawful act may spread much wider. What about the effect of regulations or decisions on a class of people or on the physical environment? Presumably all those factors that are set out in subsection 8 will assist the court in reaching a conclusion. And we see in the explanatory notes, as I say, the sort of thing that the government has in mind. Suspension or altering the retrospective effect of a quashing order may afford the defendant time to remake their decision. The diverse circumstances of possible cases make it difficult to assume that any one remedy or combination of remedies would be most appropriate in all circumstances. It's more a statement of hope, I think, than expectation. And of course, issues, as I've mentioned, such as unfairness or discriminatory actions do come forward as matters of considerable concern. Indeed, interestingly, in paragraph 9, the explanatory notes suggest the government may even think that the powers may only be exercised relatively rarely, but sees them as extending the court's discretion. Interestingly, and thanks to David Locke for mentioning this to me, there was a decision by Mr. Justice Chamberlain on Friday last week, a case of D4 and the Home Secretary, 2021 EWHC 2179 admin, where the question of the court's power to suspend declarations arose, not quashing orders. And in that case, there was clearly argument. This was a case where regulations had been made about the notification of removal of British nationality under the British Nationality Regulations 2003, where a power was granted to specify how notice could be given. And Mr. Justice Chamberlain understandably held that did not include power not to give notice. The claimant was in a camp in northern Syria, had been accused of terrorism, and she could not be notified. And he held that the regulations were outside the powers of the Act. An argument arose as to whether the declaration should be suspended pending appeal, and even on that point there was not agreement. And all that Mr. Justice Chamberlain has done for the moment is to suspend the effect of his order pending the receipt of further submissions on the issue. So there may be some interesting law in his later judgment on the remedies, which may help inform the way the courts may react to the subsection 1 powers. Clearly, in practical terms, the use of the power may require clear evidence or proposals from the respondent as to what will be done to correct the injustice or the defect. And as I've said, this is an area where the government clearly sees it as being helpful for dealing with delegated legislation and similar provisions, and therefore the issue about the implications for more than one person, for classes of person, those before, those thereafter, those affected afterwards, are all going to potentially arise, and clearly the court may well require further evidence. And it does clearly create scope for satellite litigation. We see even in the D4 case, there's a dispute about suspending the effect of an order pending appeal. There is bound to be complexities arising, perhaps needing further evidence, as I mentioned, proposals to be put before the court consider whether to exercise the 29A powers, or whether it's bound to apply the presumption in 29A9. It may even need new procedural rules. In any event, what is clear, to my mind, is that it extends well beyond the current position where the court may consider whether or not to decline to quash. See, for example, sections 31(2)(a) to 2(c) considered by the Court of Appeal in the Plan B case. That bit was not criticised by the Supreme Court. So this just sets out similar considerations to those I've already mentioned. One has to ask, in the case of amending regulations, how quickly a government department would be able to get amending regulations through. What about in cases where the government didn't have a great majority, or there was a dispute within the ruling party, and the possibility for difficulties in terms of conditions or undertakings, and indeed the speed of creating remedies in the form of action other than the quashing order, may well be issues that arise before the court, and on which the court will require assurance, because ultimately one has a gut instinct that if something clear, satisfactory and relatively speedy doesn't come forward, the court is much more likely to say, well, adequate redress is not provided, the order's quashed. And as I say, the scope for dispute includes to what extent adequacy will turn on whether redress is provided just to the claimant, or it's proposed to be provided to a class, and if so, how and in what form, how it's going to affect others and those who wait the outcome of the case, and issues such as fairness and discrimination between different persons who may be affected differently by the order. And then, as I've said, I've just included the fact sheets. There's an example of suspension order. The fact sheets do not go out of their way to consider complex situations. They are statements of what may be regarded as simple and obvious cases, and do not grapple with the sorts of problem that I've just identified. And you see at the bottom, this might allow the public body to prepare transitional arrangements, providing the unlawful action couldn't continue to be enforced against third parties. Well, that itself begs a number of questions, including some of those I've already mentioned. And then limiting retrospective effect. And again, a simple example is given, dealing with a regulatory scheme and consideration of significant economic consequences or prejudicing the well-being of third parties and similar matters. Again, there are indicated in these examples potential issues that are not addressed, and fairness and other related issues which will have to be considered on a case-by-case basis. And one feels instinctively that it will not be as simple as these examples suggest, because the court will require to know specifically what is being proposed and specifically how long it's going to take. Thank you very much. I'm now handing over, I think, to Richard Drabble.
Thank you. I'll just take control of the screen. Now, the topic that I've been given to talk about, somewhat against my better judgment, because I'm not actually sure at this stage in the history of the argument about judicial review of decisions to refuse permission, how much there is now to say. We may well have reached the end of the story. But the topic of the reversal of CART is, as David Locke has indicated, one that is close to my heart, because I was one of the counsel that argued CART both at first instance in front of Sir John Laws, in the Court of Appeal and in the Supreme Court. and regarded it, frankly, as one of my successors. So there's a tinge of sadness about seeing CART disappear, if that is what's going to happen, as a result of the new clause 11A. But before we get on to any more detail, I think it is worth acknowledging at the very outset that CART was the product of a unanimous Supreme Court, which fashioned a policy approach which they thought was acceptable, but which has led to a very considerable disquiet amongst the judiciary, particularly in the Court of Appeal, who are having to deal with a whole mass of CART judicial reviews of a sort which I don't think the Supreme Court did originally foresee. The impact has been much bigger in terms of the volume of litigation generated, but the impact has not been very great in terms of success, so the government say, in terms of their statistics. There's some doubt about the statistics, and some of us certainly do feel that there were more successful CART judicial reviews, either by actual success in the court or by government caving in once the threat of the grant of permission or indeed the actual grant of permission has arrived on the horizon. There may be, many of us think there's probably a bigger impact, positive impact for claimants than government acknowledges. But nonetheless, one has to recognise the degree of judicial resistance and unease, even amongst the members of the original court, like Baroness Hale, who were parties to the decision in court. So can I then move from that very short introduction to saying to the slides and to what I want to address? As I probably hinted already, I want to be pretty short about this because of where we are in the CART saga. So the talk is designed to address shortly, first of all, the actual mechanics of the provision reversing CART, and it's worth going through that in just a little bit of detail. It's not very long, but it's the heart of the heart of what I have to say. The possible use of the mechanics of the provision reversing CART as a precedent for other ouster clauses. The common law approach to statutory interpretation. Now, by that I don't mean generally all aspects of statutory interpretation. What I was meaning to say, what I was getting at, is the common law approach to statutory interpretation in the sense of accommodating or not accommodating prospective-only rulings. Because that's one of the issues which is not really dealt with in the explanatory material about Clause 1, which David Elvin's already addressed, that does need to be taken on board. And as part of that issue, how you, the court, are going to approach statutory interpretation in the sense of deciding that your ruling will only have a prospective effect, and how that relates to the fact that this identical issues of statutory interpretation can arise both by way of judicial review and, in my world, in separate statutory appeals. So if we go on to the mechanics. The mechanics work by Clause 2 inserting a new Section 11 large A into the Tribunals, Courts and Enforcement Act 2007. And CART is very much a creature of the role of tribunals in the as created following the legate reforms in the Tribunal, Courts and Enforcement Act 2007. And one of the constitutional issues that lay behind CART is whether, say, the upper tribunal is truly on a level footing with the High Court, what precisely that involves, whether what weight one gives to a perceived need to preserve the integrity of the tribunal system. Anyway, the new clause 11A provides, first of all, subsection 1 subsections 2 and 3 apply in relation to a decision by the upper tribunal to refuse permission or leave to appeal further to an application under section 11(4)(b). Subsection 2 provides the decision is final and not liable to be questioned or set aside in any other court. B, in particular, A, the upper tribunal is not to be regarded as having exceeded its powers by reason of any error made in reaching the decision, and B, the supervisory jurisdiction does not extend to, and no application or petition may be made or brought in relation to the decision. And then further provisions, importantly in subsection 4, which states that subsections 2 and 3 do not apply so far as the decision gives rise to any question as to whether the upper tribunal has had or had a valid application before it, any question as to whether the upper tribunal was properly constituted, or any question whether the upper tribunal is acting or has acted in bad faith, or 2, in fundamental breach of the principles of natural justice. So that's the basic structure. One goes back, just taking it part by part, and going back to 11A 1 and 2. Just pausing at 1 and 2, how effective an ouster is this? If one thinks of an attack on the effectiveness of this language on the lines of Anis Minnick or in Privacy International or whatever, just look at 1 and 2. You've got to identify a decision by the upper tribunal to refuse permission. It's got to be further to an application under section 11(4)(b). Well, what is a decision? David Elvin has already hinted at the arguments that have flailed around about the impact of nullity. Does a decision mean a valid decision, a purported decision? What does it mean? Subsection 2, the decision is final and not liable to be questioned or set aside in another court, any other court. Word final is another ambiguous one. It's used in some social security legislation to mean the decision is immune from collateral attack, not that it's unappealable. And the word itself wouldn't be enough to say it's not judicially reviewable. The following words get closer to that: not liable to be questioned or set aside in any other court. But one again wonders whether with a court that was very hostile to the ideal of ousters, that would be good enough. But then one comes on to the further pieces of the mechanics. The upper tribunal is not to be regarded as having exceeded its powers by reason of any error made in reaching the decision. That's coming close to saying it won't be regarded as ultra vires or null. It will be a decision because it won't be a decision which exceeds the upper tribunal's powers by reason of any error made in reaching the decision. And then B, the supervisory jurisdiction does not extend to, and no application or petition may be made or brought in relation to the decision. Now, in my view, this may not matter because they do exist, but if subsection 11A(3), A and B did not exist, one would have some doubts about whether this was an effective ouster preventing challenge by way of judicial review or a decision refusing permission to appeal. But A and B do exist, and it seems to me that it is highly likely, in fact almost inevitable I would put it, that any court confronted by an attempt to judicially review a decision of the upper tribunal refusing permission to appeal to itself, would look at the totality of 11.2 and 3 and come to the conclusion that there was a deliberate intention to oust judicial review, and would say that that intention had been successful. So one had been fairly slowly through the mechanics of 11A, 1, 2 and 3, but as I said at the very outset, come to the conclusion that one might well have come to the end of the cart saga. This will be an effective ouster clause. The other provision that we need just to bear in mind if one's looking at the detail is subsection 11.4. The final bullet point on the slide we've just got to is whether the upper tribunal is acting or has acted in bad faith, or forget that. One would expect, if anything ever arose on the basis of an allegation of bad faith against the upper tribunal, that judicial review would indeed lie. The other exception, which reflects some of the thinking about the validity of ousters in the lead up to these reforms and so on, is the exception that relates to fundamental breach of the principles of natural justice. That's possibly a difficult concept. What it postulates, presumably, is that there might well be a breach of the principles of natural justice, but it's not a fundamental breach. That may or may not need to be teased out over time, possibly not, because I suspect that the times when an allegation of breach of the principles of natural justice in a case of an application for permission to appeal are going to be fairly few and far between. But there is that one issue that arises under 11.4 about what is meant by a fundamental breach of the principles of natural justice. Now, the background, just to highlight what has happened in relation to this ouster compared to what happened in CART, that the contrast with CART itself is quite instructive. There was undoubtedly a large number of indications, there were undoubtedly a large number of indications that the intention at the time of the enactment of the 2007 Act was that the upper tribunal would not be judicially reviewable, and that the tribunal system enshrined in the 2007 Act would be a self-contained system which was constitutionally acceptable precisely because it provided a way through to the Court of Appeal and Supreme Court ultimately to an expert tribunal body, the first-tier tribunal and the upper tribunal, that was satisfactory in Article 6 terms and more generally. But the only sign that appeared on the face of the statute, the 2007 Act as originally enacted, was the designation of the upper tribunal as a superior court of record. And the government said, well, you can't judicially review superior courts of record, that's axiomatic. And there was indeed some indications at the Employment Appeal Tribunal level, and I think one other similar point in the tribunal hierarchy, that was the case. But Lord Justice Laws demolished the argument at first instance. He said that it was a constitutional solecism. The quote in the slide is actually a quote from Baroness Hale, but she's reciting the argument that John Laws put forward in the judgment of the Administrative Court. And he said it was a constitutional solecism to consider that merely to designate a body a superior court of record was sufficient to preclude judicial review. This could only be done by the most clear and explicit language and not by implication, still less by what was effectively a deeming provision. The rule of law requires that statute law be interpreted by an authoritative and independent judicial source. The need for such an authoritative judicial source cannot be dispensed with by Parliament. the requirement of an authoritative judicial source for the interpretation of law means that Parliament's statutes are already effective. And he went on to say that in order to fulfill that function, you needed a court of universal jurisdiction, as opposed to, like the High Court, as opposed to a court of limited jurisdiction, such as the upper tribunal. And many people think that it's at that point that the cart went wrong, because the thinking behind that is to play down the authority and legitimacy of the tribunal system leading to the upper tribunal as a source of solid law and authority. And 11 large A is obviously intended to put that back. So, and that's the point where we are in March. I think we can see your tribunal lawyer, and I suspect if you're Baroness Hale, you might well see 11 large A now as a vindication of the tribunal system rather than a denial of its legitimacy. Nonetheless, I still wish we'd held on to CART. But that's all I want to say about CART. The one other theme that I put forward in this talk is closely related to what David Elvin was saying about the presumption in favour of the presumption against quashing orders, or quashing. That's the further. And the other theme is just to put into the mix about how the provisions that David Elvin was discussing are going to actually work. An issue that I've had to deal with on quite a large number of occasions, which is that you can take the same point of statutory interpretation either by judicial review or by statutory appeal. So that, for example, you may well find that an issue arises in relation to housing benefit regulations, which a claimant can take on judicial review. But precisely the same point of statutory construction arises in a statutory appeal, where the body ruling on the point of statutory interpretation is obviously not does not have the remedial discretion with or without the power to suspend the quashing order. It simply has to rule on the individual merits of the case in the individual case. So that, to go back to Martin Chamberlain's example of suspending the effect of a declaration, it's actually conceptually very difficult if you're seeking you, the court, are seeking to suspend something where the judgment you have just given produces a binding ratio that will bind other appeal tribunals. So where does this leave one in terms of cases of pure statutory construction? This is an actual quote from Lord Nicholls in Spectrum. David Elvin referred to this judgment, and it's quite an important judgment when thinking about this. But it puts in place the conventional approach to statutory interpretation, the reluctance of the UK courts to contemplate prospective-only rulings, and what Lord Nicholls said, having referred to cases of where one is dealing with the law as a living instrument, the Human Rights Act and so on, which is what he means in the first sentence of the quote, cases of these types are of increasing importance. But then he goes on to say, and this is really what he obviously saw as the conventional approach, leaving these aside, the interpretation the court gives an Act of Parliament is the meaning which, in legal concept, the statute is born from the very day it went on to the statute book. So it is said, when your Lordship's House rules that a previous decision on the interpretation of a statutory provision is wrong, there's no question of the House changing the law. The court is doing no more than correct an error in interpretation. Thus there should be no question of the House overruling its previous decision with prospective effect only. If the House were to were to take that course, sorry, there's a typo coming to that, it would be sanctioning the continuing misapplication of the statute so far as existing transactions or past events are concerned. House has no power to do this. Well, he went on to say the House did have power to do it in a truly exceptional case. But to go back to my more routine Social Security example, you have in judicial review an issue of interpretation of a Social Security regulation. The Court of Appeal says it means X. The first tier tribunal then has, in a statutory appeal to rule on it, well, it must apply the ratio, I would say. And it's very difficult to see how the powers to suspend and the presumption in favour of suspending and so on play into that fairly commonplace scenario. It may be that these powers are just not meant to be available in cases of pure statutory interpretation, or that the courts will very rapidly rule that they're not available in those circumstances. Anyway, that's slightly gone over my time, actually, but that's the gallop through of what I needed to say, and I shall hand back to David Locke. Thank you.
Thank you very much, both to Richard and David, for some extremely interesting observations on drafting, which is not entirely straightforward, if I can put it that way, at the best. We've had one question, which I'm going to pass back to David Elvin, if he'd be so kind, raising the potential tension between 29A8 and 29A9, which I must say is something that has occurred to a number of us looking at this, because they do sit together in some ways, but there's also a tension between them. David.
Well, I've already touched on some of this in my presentation. I mean, clearly, 8 must go to the question of whether to exercise the powers, and in a sense, I can see 8 and 9 being wrapped up together, because if you're being asked to include or to invoke the presumption, then you're going to look in terms of adequate redress at the factors in 8. In any event. So I think the two will probably go together. But I think the question raises the interesting point as to whether the court will have to consider it. Well, I suspect the answer will be it depends on the government department or other impugned decision maker that's sitting there. But if the decision maker puts forward something under subsection E in section 8, that is to say, suggests a course of action, the imposition of conditions, or gives an undertaking about reconsideration or amending the defect, I think the court then has got to consider the operation of subsection 1 and the suspension or modification of the quashing order, in which case you get into that satellite litigation, which I see as inevitable, because if this issue is raised, unless it's purely a limited attempt by the government to avoid the inevitable, the court will want to see evidence, and the court will want to be properly informed as to how the matter will proceed. Now, whether someone tries to short circuit that by putting the evidence in with the claim and pleads it in detail, or whether waits to see what the court's going to do and then asks the court to operate section 29A1, it's not entirely clear. I've said, and the question raises it, that it might be useful to have some procedural rules, or at least a practice direction in due course, to know how the court proposes to deal with those matters, whether it requires them to be front-loaded so the court can consider it all at the same time as the judgment, or whether it is going to be ex post facto arguments about remedies.
So we could end up in a situation, David, where a judge hands down a draft judgment.
Yeah.
The response of the government is to say, please can we have 28 days to try and decide how to respond to this appalling judgment. By the way, we're also seeking permission to appeal. But in the meantime, assuming that we don't appeal, or that we don't get a stay from the Court of Appeal, we also want time to try and work out how to correct things. So don't do anything for 28 days while we go away and talk to ministers. And then they come back and they say, we've now talked to ministers and this is our proposal. The claimant says, well, that's hopeless, and responds. And it could be several months before the decision actually takes effect.
Yes, I mean, as I say, that's why it would be appropriate, I think, to have a practice direction that basically says, well, if in the event that the decision is quashed, the court will want an indication from the relevant defendant as to what course of action is likely to be taken. The problem is the relevant defendant isn't going to want to start giving suggested undertakings or timescales for correcting, because that department or other defendant will be fighting its corner. So it does seem to me fairly likely that there will be a prolongation of the process, which doesn't seem to me to be in anybody's interests, other than perhaps government is trying to save some money by not having a retrospective quashing order.
Richard, is there anything you want to add to that?
No, I don't want to add anything to that. No.
But what I am going to ask you to answer the elephant in the room question, which is, can the cart ouster a precedent for further ouster provision in legislation? In other words, is the wider principles that I spoke about at the outset simply going to come out using this model in further legislation?
Well, but I've seen the further question, and I think I vaguely promised in the slides that I would say something about this and haven't done. My own inclination is to say the answer to that is no. One reason for going fairly slowly through the actual structure of 11A and coming to the view that it was likely to succeed at the end is that you will get in front of a judiciary in a cart situation with a favourable wind behind you, the government, because they clearly do feel that in the particular case of the structure of the 2007 Act, there is a lot to be said for protecting the integrity of the tribunal system, which means giving recognition to the role of the upper tribunal. Now, many of us with practical experience of the upper tribunal on a day-to-day basis know that sometimes it's marvellous and other times it's not, but there's a very strong feeling amongst the judiciary, if you talk to them, that it is actually appropriate to recognise the pyramid which includes the upper tribunal at the top of a self-contained tribunal system. Now, I think the government will be much more reluctant to do that without that sort of fair wind behind it. Certainly the impression I got as we went through the process. I mean, the original discussions in terms of ousters were that the government at least, maybe not the departmental lawyers, but the government were thinking about the desirability of ousters on a fairly widespread basis. That hasn't happened. And the only thing they've got to show for that are descriptions that the CARP model could act as a precedent in other cases. Well, obviously some of the language could, but that's always been the case. In the right context, it's always been possible to devise an ouster that worked, but the context has to be right. So I suspect that we will not see a rash of ouster clauses in other contexts. I don't think the CARP clause are breaking all that much new ground, actually. We've had an ouster defending decisions in which the 6-week time limit is expired in planning cases. I was going to say since 1947, I don't know whether it is or not, David may know, but for a very long time, which has just been upheld by the court with almost, one would say, with enthusiasm. So you can do it. And that was the message that I was quite keen to try to convey during the course of the consultation procedure. You tailor-make your ouster clause, not generally as a widespread precedent, but because you're dealing with a practical problem in the particular jurisdiction. And if that's what you're doing, courts may help you. I don't know whether that helps. That's my answer anyway.
Well, takes all the way back to Smith and East Ello and
Yeah.
cases like that. David, anything to add?
No. As Richard said, I mean, we with the Bar Council reps, both the round table meeting I had with the Ministry and Richard's written reps, I mean, this issue was tackled head on, and the same point was made that you need tailor-made ouster clauses. You can't just have one size fits all. You've got to look at the specific context and the justice of the specific context.
Thank you very much. Well, ladies and gentlemen, it's 12:15. Thank you very much for attending and listening. I hope you found this interesting. Thanks for the nice comments which have come back. We will obviously have to see how the bill progresses through Parliament, whether it is passed in its existing form or whether there are amendments. And when it's implemented, as David has indicated, precisely how it's done, whether there are new rules, whether there's practice directions and so on. And we'll keep an eye on that. And if there's anything significant that happens, we'll keep people updated. But meanwhile, thank you very much for listening. I hope you found this interesting. Good day.
Thank you.